The Plant Variety Protection Act was passed in 1970 by Congress, and in that it gave the USDA the power to give certificates of protection towards different breeders and farmers for up to 25 years if they were eligible after all the tests and everything. All the paperwork had to get filled out, and it gave them exclusive rights to a patent on that plant. They were the only ones that were allowed to produce that plant for sale. Nobody else for that time span while they had the protection was allowed to produce that plant for sale. And basically the reason of this was, farmers would breed plants and everything, and then they would sell them to different companies and different, and for the turf industry, different sod companies. And then after that was it. They weren't needed anymore. After they gave them the initial seed, they weren't needed anymore. And the sod company could then just use that seed that was produced from the plants they were growing, and then produce more plants, and also take seed produced from those plants and sell those in the field. And so this was basically to protect from that. It impacted the turf industry drastically. It protected the breeders. It brought in the urge for more research, and with the more research, you begin to find different varieties and cultivars. So within the act, researchers are also protected under an exemption clause, and this exemption basically gave researchers the right to study the seed and try to find new cultivars and new varieties. Patented seeds were made available to the researchers, and through this they would either make genetically engineered seed, or they would find a completely different seed to be sold on the market. But the seed had to have a distinct and uniform and stable attributes in order to be taken as a different cultivar or variety of the initial plant.